Day 2 of the West Court panel. Again, I'm honored to be sitting with Judge Clement and Judge Elrod. It's day 2, even though it's Wednesday, so we'll try to calibrate. We have 3 cases on to be argued today. We'll probably go straight through, but we'll see how it goes. First case up is number 21-40253, United States versus Hester. Mr. Volberding. Is that right? Yes, sir. Close enough? Okay. Thank you, sir. We're ready for you. I apologize if I didn't get it exactly right.
You were exactly right, sir.
All right.
German name, I confess. And often I ask courts to call me Mr. V, but today you have 2 Mr. V's. And
Well, my mother used to scold us about not having people correctly not put a D behind our name instead of the T. So, I learned to pay attention to how people want their names to be.
Good advice, sir.
Had not grown to have it, but we're glad to have it. Here you go.
Thank you, sir. Thank you, Your Honors. As indicated, I'm James Volberding, and I have the privilege of appearing before the court today on behalf of a man named Titan Hester. Mr. Hester is in federal custody. He received a life sentence plus additional time for drugs and guns, and he was tried in the Eastern District of Texas. And I would like to begin with the first issue, dealing with sufficiency of the evidence. He was charged in 3 counts. The first is a conspiracy count, and the second was gun in furtherance of that conspiracy, and the third was felon in possession of the firearm. So let me address the sufficiency count first. The first trial, there was actually a fairly large record, more than 5,000 pages, because he was tried twice. Fairly tedious reading, I confess. It was a mistrial on counts 1 and 2. The indictment alleges a conspiracy began in January 2017 with an 8-person group, that's the superseding indictment, I should say, and continued until February 2019, so a 2-year conspiracy. He was in jail for slightly more than half of that. He was arrested in May of 2018. Yet half of that trial was devoted, approximately half, was devoted to dealers in Mexico and Dallas with little connection to Mr. Hester, except 2 men who testified to link him to the Dallas and Mexican operation, when Hester's, by all accounts, appears to be a minor retail operation in Sherman. He was presented as something of a key man in the conspiracy. That is not true. At worst, the worst evidence, most strongly in favor of the government, is that he was a retailer selling small amounts of drugs out of the parking lot of a shop, a mechanic shop that he had in Sherman. He was arrested in Oklahoma in May 17, 2018, so he was in jail from that point forward. He did not bond out. And aside from an allegation that he wrote some letters and notes in the jail, I'm not aware of any evidence that he furthered a conspiracy in the jail from that arrest date onward. And yet nonetheless, while he was in jail, some of the major buys of kilo-size sales involving some of the individuals in Dallas occurred while he was in custody. May 22nd, for example, he was in jail. A man named Santos was arrested involving some kilo transactions. And when he was arrested in Oklahoma, he was stopped by Oklahoma police on a traffic violation. The police found no drugs, no guns, no records, no contraband. And in fact, he and a girlfriend were heading to what appears to be a vacation home or some sort of other home he rented in Oklahoma, and no indication that involved drugs. And while we are glad that he was not tagged in the pre-sentence report for all of the drugs that came from Mexico, nonetheless, in the trial on the conspiracy, all of those kilos were presented as evidence against him. There were witnesses, and of course, the record is replete with co-defendants who testified, and you know the pattern. They did a plea agreement, and the sentencing is ahead of them, plea is behind them, and our contention is that those witnesses are not credible.
Those arguments were made. The charge included those. That's up to the jury, isn't it? Isn't this a jury? They did testify. What they said was enough to convict him. They were correct, the jury was correctly charged that the dangers of relying on that, and also the video evidence from your client's shop. So how can you argue sufficiency? Why isn't this just we're not the jury, we can't redo it if there is evidence in the record to support it?
Yes, Your Honor. It's an accurate observation. I was aware of it when I wrote the sufficiency claims. Of course, it's always been the law in the Fifth Circuit, and I concede those points. There is certainly some evidence, the government would say a lot of evidence, but certainly some evidence in the record to show testimony from co-defendants. Okay, that's for the jury to sort out. Video shop, his own video shop surveillance, that's for the jury to determine. Are those guns or something else that he's carrying in the video, or drugs? That's for the jury to determine. I concede those. My position is that when you take the evidence as a total, when you evaluate the credibility of the witness, even though a witness can be cooperative and can come to court and can tell the truth, that sometimes that is not reliable evidence. Some jurors would conclude that the testimony by Amy Lashley, for example, you saw her, you must have run across her name in the record. She was cross-examined at length, and I spent a great deal of my reply brief going through all the contradictory testimony.
Right. And some jurors, as you said, might not have believed her, but for whatever reason, this jury did. Perhaps. Yeah, I mean, so I just don't know where you get with it. So, respectfully.
I understand, and I accept that, Your Honor. I fully accept that. I wish I had brought you an easier case.
Yeah, it's not frivolous, but, you got to raise something. And you're CJ opponent, so.
It's a challenge.
Yes, so, you're, do what you can. But Judge Elrod hit on a point, and that's that there was vigorous cross-examination of the witnesses, which you just acknowledged, right?
That is correct, sir.
All right. So as she says, a matter of us sizing up what the voluminous record shows and framing it against what you argue on the other side, right?
Yes, sir.
And I'm not trying to cut you off. If you want to talk about that some more, I wasn't trying to cut you off in any way. And it is a vigorous cross-examination, as Judge Stewart says.
It was a very vigorous. I'll compliment his attorney in that respect. It was very vigorous. And because there was the advantage in the second trial of having the transcript of the first trial, there was additional basis for effective cross-examination. I certainly concede that. And so I would leave the first issue, the conspiracy.
What was the point about him not speaking Spanish? Was that to try to show that because he didn't speak Spanish, he was somewhat attenuated from these other main players who were Mexican or something? Was that the point of that?
Yes, sir. You're exactly right, and that's my point. And I'll finish that first issue with the conspiracy with that very comment. The government issued a sealed indictment 8 days before he was arrested in Oklahoma, and that alleged a conspiracy with 2 other individuals, and there were no gun counts or anything else. And so that was the reason they wanted to arrest him in Oklahoma, is on that warrant. So, but it appears that in developing the case, government may have thought he was a bigger fish than he really was, because they were dealing in Dallas with kilos coming in from Mexico, and there were a number of Hispanic-speaking individuals in the case, some in Mexico, some in Dallas, who were caught with kilo-sized shipments. And they may have concluded that Mr. Hester was integral in that in some way, which led to him being prosecuted in this case, and all this evidence coming rolling in. But if you step back and look at it, he's not. He is involved in, as Judge Elrod mentioned, there's testimony from the co-defendants, putting him in a retail operation, small amounts of drugs. But he wasn't prosecuted that way, sir. It wasn't that kind of trial where the co-defendants came in and simply told their participation with small amounts of drugs. A big part of the trial was him being some sort of part of this enormous Mexican smuggling operation. That's what we say is problematic.
Well, he did seem to think that he was important to this operation, because how would you explain the organizational chart in the auto shop that showed him at the top?
The evidence could be looked at in 2 ways. If he had just been prosecuted for just running a shop and having distribution, there would have been him plus 7 other defendants. And so the government could have charged him with a conspiracy, and they did, with those 7 other individuals, or 8. and said, he's in charge of these 7, he's the big fish among those 7, and just left out all the Mexican smuggling operation, but they didn't. And so the government presented him on, I guess, on charts in the courtroom with, here's Hester, here's these little people, here's the big fish from Mexico in the Dallas operation, making him appear much larger and much more dangerous than he was, and that's our objection. So I don't know if that answers your question exactly.
Well, it's an attempt.
It's an attempt, and so, but yes, our position, and it, as Judge Elrod indicated, is I recognize the responsibility of the jury to sort out the believable from the non-believable, but at some level the court has a role of evaluating whether that's reasonable under the circumstances, and we challenge that. With regard to the
the gun possession and so forth, for those the ones you most want to get to, or your suppression arguments, which I'm not suggesting you abandon any of them, just looking at
I understand. I'll do both. I have ample time. I'll touch on the gun cases first. He was, as indicated, arrested in Oklahoma, no gun. The police searched after he was in jail in Oklahoma. They quickly searched his business in the middle of the night, and they found an old shotgun. That was what they found. And I think they were disappointed, and only found a shotgun and a small amount of drugs. And then they went and searched a few hours later in the early morning hours his apartment. And so, but with regard to the second count, the gun and the distribution, no one saw him fire a gun. No one saw him point a gun at a co-conspirator. There was no testimony by the co-defendants that the guns even worked. There was no threat to shoot anyone. And the ATF agent who testified and established that the guns seized in the apartment, the 2 in the apartment, and the shotgun, they did function, but there was no evidence that said those 3 guns, those tangible guns, 2 in the apartment, 1 in the business, were the same weapons seen in this shot video. And so the evidence on the second count has to be he had weapons. Those weapons, because those are the ones in the indictment, those weapons were the ones he used to run his drug operation. But there's no indication the 2 in the apartment had anything to do with the drug operation. Yes, ma'am.
No, that's okay. Keep going.
Yes, ma'am. Let me continue, Judge Stewart. You asked about the Fourth Amendment issue. And there's a supplemental record, and it's bait stamped. And the search warrant for the apartment, I say for the apartment, is 5887. And that search warrant simply says, go search the apartment for the property described in the affidavit. The next page, 5888, is the search warrant affidavit for the apartment. The officer said to the judge to get the warrant, Judge, we think that there's 3 types of contraband in that apartment. Contraband 1, currency, cash currency. Contraband 2, records, receipts, books, ledgers, paper documents of drug activity. And 3, photographs, computers, images, things of this nature that are incriminating in some way. It doesn't really say. There's an additional item. There's 4-item listings. 1 is redundant. But the officer in his affidavit said nothing about drugs, no indication of drugs in the affidavit, in what he was searching for, I should say, in the items that he wanted to search the apartment for. Nothing. He did not say, we want to look for drugs. We did not want to look for guns.
Did Mr. Hester challenge the district court's ruling that the suppression motion was untimely?
It was not filed timely. The suppression motion was filed 27 days, if I'm correct, after the deadline put in Judge Mazant's scheduling order. Now, this was in the first trial, which was some months before the second trial. But in the first trial, the judge issued a standard discovery order. This motion to suppress was filed 27 or 28 days after the deadline of that. And Judge Mazant commented on that in his written order, saying it's untimely filed, but then went on to consider it on the merits. And the judge may have decided that was appropriate, and I believe the rule is Criminal Procedure 12C, subsection 2 or 3, allows good cause. And so the judge may have concluded there was either good cause or no harm to the government by going ahead and looking at that on the merits. There was no delay in the case, it involved no additional witnesses, caused no undue expense. The judge went ahead and reviewed that issue and ruled against Mr. Hester. So we do not consider that apartment search to be waived under that.
I don't believe it's waived. Why wouldn't the good faith exception apply? And alternatively, do we have to review this under plain error?
Now, that's the business search, yes. Under the apartment, well, I'll break it this way.
For the auto shop, do we have to review under plain error? And on the apartment, is the good faith exception applicable?
Time goes by quickly. I'll say the shop was not preserved. That issue was not preserved with a timely motion at all. The apartment search was untimely motion, but it was conceded on the merit. You can get to that one on the merits if you choose to.
But on the merits, would the good faith exception apply?
No, I would think not, yes. And I explained in my brief. Would you like me to address that?
Yeah, please, address the question.
I recognize that even if there were mistakes made in the search, the good faith exception can come along and help the police. My argument is that when you look at the affidavit for the apartment, not put aside the business, the affidavit has paragraph after paragraph related to, oh, look at the evidence and probable cause for the business. But that wasn't the issue, it was the apartment. So what the officer did is, gee, we don't have a whole lot of evidence except something someone said, some co-defendant said 6 weeks earlier. We'll sandwich that into the middle of this affidavit. And at 5 in the morning, the judge isn't going to read it. He's just going to, the judge will read it, and here it is, sandwiched in the middle. Okay, lots of activity at this business, not pretty sketchy about what's in the apartment, and nothing in the affidavit about drugs or guns in the search for the apartment. You see, and that's our contention. I don't know if that helps.
Thank you.
Thank you very much.
Thank you, sir. You've reserved your rebuttal time. We'll hear from the government.
Good morning, Your Honors. I'm Visosky for the government. Counsel, may it please the court. With respect to the sufficiency challenges, this case is a little bit unique in that we actually have video evidence of actual drug distribution and drug activity occurring within Mr. Hester's auto shop. In fact, in Mr. Hester's opening brief at page 12, he says in the April 2018 auto shop security videos recorded by Mr. Hester, obtained by Sherman PD from its May 2018 search, showed Mr. Hester removing drugs from an office safe, handling firearms, and co-defendants selling drugs. And in preparation for the oral argument, there are citations in the brief, but just in preparing for this argument, I spent more time just watching the video, and it shows Mr. Hester taking methamphetamine from bags, putting it in a plastic clear cup, weighing it on a scale, and then putting it in smaller plastic baggies for further distribution. And there are also, on the videotape, it shows customers coming in, Mr. Hester greeting them and sometimes counting the money, and either he or his co-workers, Leon Fields in particular is one that's on the video a lot, distributing methamphetamine and then recording the transactions in drug ledgers. And in terms of the scale of the operations, just as an example, in the video is Exhibit 132, May 11th, 9:01, that video shows Leon Fields counting money, Mr. Hester putting on latex gloves. He locks the door in the office that they're in, so that no one gets into the office where the drug activity is occurring. The mechanic shop is outside. He takes out a bag of around a kilogram of methamphetamine, and that's at 3774 of the record. And Leon Fields, he was there, told the agents that this was the normal practice of this operation after re-upping the methamphetamine from Dallas. And that was the routine practice of this organization, is Mr. Hester himself would drive to Dallas, meet Mr. Astron, Royal Astron, either pick them up on the side of the road or in a motel, go to a stash house. Mr. Astron would go inside, get the methamphetamine, come back, Mr. Hester would pay. And on one of these occasions, Mr. Hester offered Mr. Astron a pistol that he had to take into the stash house, and Mr. Astron said, no, I'm good.
Was there any explanation given as to why this man would video his criminal activity?
Well, it was intended for security measures, so there were cameras outside as well. I think obviously he just never intended to, seizure that would get the recorded activities. So I think it was for protection, possibly so he can monitor even his workers to see if they were stealing from him or whatever internally. But I mean, it certainly is powerful evidence that the jury saw. And also, the videos were not available for the first trial. There was a technical problem with them. Judge Mazant, there was a technical problem with the videos. They took it back to the U.S. Attorney's Office during trial, like one last trial. Let's see if we can get these to work. They started to work. And so the government tried to get them in, and Judge Mazant would not allow them into the first trial. He said that you have enough, you don't need the videos. But they did come into the second trial where there were the convictions on the first and second counts. In terms of there's the video evidence, there's the co-conspirator testimony, and there were a number of co-conspirators, and these weren't remote people that had heard of Mr. Hester. They're the people that are in the shops with him, saying that this was the operation. They all testified to the practice of Mr. Hester going to Dallas to re-up with his stash of methamphetamine. Occasionally they would accompany him, come back, break it down, and sell it. And Ernest Greenwood testified that it was up to a pound per trip, and there were multiple trips to Dallas to pick up the methamphetamine. And then, of course, there was the fruits of the search and seizure. At the auto shop, there was around 35 grams of methamphetamine. The Mossberg sawed-off shotgun that had Mr. Hester's initials engraved in the gun, and he was a felon. He could not possess a weapon. Ernest Greenwood testified that was Mr. Hester's baby. And there was everything that you saw in the video. There was digital scales, the drug ledgers, and ammunition, including 12-gauge ammunition for the Mossberg shotgun. At the apartment, there was more methamphetamine, 343.6 grams of actual meth, body armor, again, digital scales. There was testimony from Ernest Greenwood that Mr. Hester used his office at his apartment to engage in his drug activity, and that's where they found numerous drug ledgers, and that's also where they found the Smith & Wesson semi-automatic pistol that was loaded in that office. In terms of the suppression issue, Your Honor, I think Mr. Hester kind of misses the mark in arguing that plain error applies. It's not a matter of plain error. There's no question that Mr. Hester concedes that he did not challenge Judge Mazant's timeliness ruling. Well, first of all, he didn't file a motion for leave to file it out of time. Second, he didn't file a motion for reconsideration or any sort of objections to Judge Mazant's ruling that it was untimely. But the point is that he didn't raise that as a point of appeal on appeal. So the untimeliness ruling represents just an independent ground for summary affirmance.
I think that his position is that because Judge Mazant, the district court, went through and analyzed it on its merits, that we can look at the merits. When a district court says something's untimely but then goes on and addresses the merits, that we are free to look at the merits.
Well, I think it's either or, Your Honor, and that.
But from your standpoint, if it's as you say it is, does it really matter?
It doesn't matter. It doesn't matter at all. The good faith exception clearly applied here. This officer had a warrant signed by a judge. The affidavit was detailed. And true, there was a lot of information in the officer's affidavit about the auto shop coming from co-conspirators and traffic stops of people coming from the auto shop that had methamphetamine, and they say, well, it came from Mr. Hester's auto shop. But it also had evidence relating to the apartment as well. CI2, who was Ernest Greenwood, told the officer, and he reported in his affidavit, that he continually went inside Mr. Hester's residence frequently until about a month before, this was May 2018, when they had a disagreement. He said, every time I went there, I saw marijuana, and I also saw methamphetamine, cocaine, pills. Mr. Hester was selling Xanax pills at his home office. And he also testified that Mr. Hester had drug ledgers in his office. So based on all of that information, the officer's reliance on the warrant was certainly reasonable. And the affidavit was sufficiently detailed, and there's also the accusation in Mr. Hester's brief about misrepresentation by the officer, and there's certainly no evidence of that. This officer did not misrepresent anything. There's an argument about the staleness. We think it's a bad argument, but that's one thing, and we're only talking about a month here before Mr. Greenwood said that he continually went inside Mr. Hester's apartment. But in terms of misrepresentation of facts, that's simply not true. And Judge Mazan was correct, looking past the good faith exception, just on probable cause, that there, and he said, I sat through, no, I'm sorry, this is later. But he said there was probable cause because there was evidence within the affidavits of ongoing criminal activity. And he correctly recited this court's law that, you can look back a little bit further when there is a pattern of ongoing criminal activity, as there was here. And we're not talking, a year, 9 months. I mean, we're only talking a month. So to call that stale is, I think, a little bit of a reach. And of course, there's also the drug ledgers, and that was in the affidavit as well, where Mr. Greenwood said that he had seen drug ledgers at Mr. Hester's apartment. And there's also a case law that says drug ledgers, drugs can come and go, but if there's evidence of drug ledgers, you can look back further for those as well. And that's the Alvarez case. In terms of the obstruction enhancement, and this is and just to clarify for the record, there's a little bit of confusion, I think, in the briefs on this. There are two communications to Amy Lashley at issue. One is just like a note. One was to Amy Lashley, one was to another co-conspirator, Jane Baker, and he's seen in the videos on the auto shop video as well. That were found, like in the recreation yard, they were posted. And those are the ones that say, for example, Amy Lashley, it names her in these notes and says, I got your statement on deck. I saw the video that you made, for one thing. And of course, she was the one that she was cooperating at the time, and more video when she went to Mr. Hester's shop under the pretext of paying him back money for some methamphetamine that she owed. So this is Mr. Hester in the note saying, I saw the video that you made. I got your statement on deck, blind, crippled, or crazy. OG calls trays up. If you talking, you ain't walking. And as Judge Mazant found, that was clearly a threat and obstruction of justice. And it names Amy Lashley. And as Mr. Hester in his reply brief acknowledges that Miranda Moore at the first trial, and again, this is a sentencing enhancement, so the judge could consider evidence in either the first or the second trial. Miranda Moore, who was Mr. Hester's common-law wife, testified at the first trial that both the note and the handwritten letter were Mr. Hester's handwriting. So it's not just Ms. Lashley's testimony that only Mr. Hester would know the information in the note about the video, but also you have Ms. Moore's testimony that it was his handwriting. In terms of the letter, that's where we get into the issue. It refers to as famous, which was her childhood nickname. Mr. Hester in his reply brief tries to make it that there was some sort of perjury going on there with Ms. Lashley. And I mean, if you look closely at the transcripts, in the first trial, Ms. Lashley said, And you have to watch the video of Ms. Lashley talk for one thing. She's just very off the cuff and just talks very fast and kind of. So she says at the first trial, testifies that, I'm not sure if he knew that was my name. He may have called me that once or twice. And the second trial, she was just more affirmative and said, he knew my name was famous. And of course, in that letter, it first starts out saying, referring to her as famous. And that's the letter where he says, let's stick to the script. We're looking at 10 to life here. Everyone needs to get on board. And Judge Bazant said that's an obstruction. I don't know what is. In terms of the sentencing enhancements, I think I'd just rely on our brief on those. One, just clarification of the record I'd like to point out for the premises enhancement, which is issue 9, at the record at 3766, it shows that Mr. Hester was the registered owner of his shop, and the evidence clearly showed through the videotape that was a premises used for large-scale drug distribution. And unless the court had any other questions, we just rest on the brief.
Thank you. I think we have your argument. Thank you, sir. Appreciate it. Okay, back to you, Mr. Volberding, for rebuttal.
Thank you, Your Honors. A couple of points. Let's just go work backwards with regard to the letter. My colleague is correct. Miranda, that's the common law wife, testified in both trials. I was mistaken in my reply, but she testified in both trials. And in the first trial, I believe she said the letter, one of the so-called threatening letters, was written by her husband. In the second trial, I don't know that she was asked that question. But there's another point in the government's favor. Greenwood, a man named Greenwood, co-defendant, cooperating, he said he testified that he recognized the letter as Hester's signature. It's on page 4059, if that's of interest. But nonetheless, be that as it may, the government also filed a motion for a handwriting expert to have someone evaluate those letters, and they failed to follow through with that. And so we very vigorously opposed the obstruction enhancement. He wasn't indicted for obstruction. That came in purely under the PSR, and the evidence is weak for that. And I laid out in the reply brief exactly why it's weak, because it relies on a developing concept, I guess, by Amy Lashley in the second trial. Judge Clement, you raised a question I thought was perceptive. You asked about this video. Why on earth would Mr. Hester, if he's dealing drugs, put a video in his shop to record the transactions? And I don't know the answer to that. But it does lend credibility, I think, to the 9th issue that I raised. The 9th issue in sentencing, he got 2 levels for running a business to deal drugs. And there's some case law that says that has to stand basically on its own. There's got to be more than just an allegation. And the record as a whole in both trials is deficient in evidence to show that was anything but a mechanic shop. Well, let me say, that's badly said. It was a mechanic shop. He actually did legitimate mechanic work there. It wasn't fully developed by the government or the defense in that, but it was a mechanic shop. That's why the shotgun was there. It was just ordinary protection, and that's why he had a security video system, is because it was a legitimate business. So our point is, on that 9th issue, the evidence is insufficient to get him that additional 2 points for running the business. It was primarily a business, and if there was drugs, it was a minor part, not a major part of what was occurring, and that's why there was a video. And so I want to lastly make a clarification on this 4th Amendment issue. I think the court may be aware, on October 12th, the court issued, when I filed my brief, at the same time I filed the brief, I filed a motion to supplement the record with documents pertaining to the business search that were not in the record. The court denied that motion in an order on October 12th. So the record as it stands doesn't have any evidence pertaining to the business search. So if it may not survive the plain error standard on that basis because it's not part of the record. So the 4th Amendment issue pertaining to the apartment is stronger because although the government would say, gee, the affidavit is replete with evidence of drug transactions in the business, the warrant itself that told the officer, go into his apartment, which gives plenty of Supreme Court case law, a home is different, go into that home and look for currency, for drug ledgers, and for photographs. It said nothing about drugs or guns searching, and that's what the officers were actually seeking. So with that, I will yield the rest of the time subject to the court's questions. Thank you very much.
Thank you, sir. Thank you to both sides. Mr. Volberding, you are part of our Criminal Justice Act panel of attorneys, and that said, in this case, we certainly appreciate your briefing, your oral argument, and faithful representation of your client, as well as the many other cases I'm sure you take on for the court. You and that panel do yeoman service for the court and for our system by taking on these cases and preparing. So for that, we salute you and say thanks.
Thank you, sir.
Thank you to both counsel for the briefing and oral argument. The case will be submitted and we will get it decided in due course. Thank you.